Thank you, Mr. Shannon, Vice Mayor, and City Council members. The substantive portion of this ordinance in its current draft state actually begins with the definitions taken from the state law that Mr. Shannon just described, and those include the terms attending physician. All of the definitions that I'm just about to describe to you come from state law, whether verbatim or with an attachment to set forth the very lengthy statutory language verbatim. Attending physician is going to have the same definition as the term in the Health and Safety Code, and it requires that the issuing physician be a medical doctor or a doctor of osteopathy, pursuant to the Medical Board of California or the Osteopathic Medical Board of California. Also, identification card, which is a component of the MMP, allowing for voluntary receipt of an identification card for qualified patients and their primary caregivers. That's also defined pursuant to Health and Safety Code, and it is a component which provides protection for the qualified patient and the designated primary caregiver from arrest unless officers, law enforcement, have reasonable beliefs to the contrary. The next definition is management member. This is a term that is defined within the medical marijuana collective for purposes of this ordinance, and it means a member of the collective who has the responsibility for the establishment, organization, registration, other supervisory oversight for the collective as a body. It also defines medical marijuana, and that definition is taken specifically from the Compassionate Use Act, which begins at Health and Safety Code Section 11362.5, and also from the Medical Marijuana Program Act, beginning at Health and Safety Code Section 11362.7. Now, the definition that is probably one of the most important components, at least within this draft ordinance, and as far as definitions are concerned, is the medical marijuana collective definition. And this has been defined as an incorporated or an unincorporated association composed of 4 or more qualified patients and their primary caregivers who associate at a specific location or property to collectively or cooperatively cultivate marijuana for medical purposes. And again, in accordance with the Health and Safety Code starting at 11362.5. As far as the ordinance is concerned, there is not a separate definition for cooperative. However, that term is subsumed in the definition of medical marijuana collective. They're treated synonymously. Primary caregiver has the very same definition that is set forth in the Health and Safety Code section, both under the Compassionate Use Act and also the MMP. Property, which is the location of the medical marijuana collective for purposes of this draft, defines the actual property, that the building, the location where the medical marijuana collective is physically located. Qualified patient, much like the other definitions, is taken directly from the Health and Safety Code and is set forth verbatim pursuant to state law. Under the ordinance that is proposed today, collectives are required to apply for and receive a permit before operating within the city of Long Beach. Without the permit, the operations are unlawful. The permit application process as set forth in this ordinance is very similar to processes used in the city for other regulated activities. And the ordinance as drafted requires that, among other things, the permit approval comes from various city departments, and that includes the fire department, police department, health, development services, and code enforcement. With respect to the application process, there are requirements that the collective permit applicant must meet, meaning that they must provide to the city specific information that includes the physical address of the property where the proposed collective will be located, a site plan fully describing the physical structure, and that includes the interior, exterior, floor plans, whether or not the property is being rented or leased. And in that case, the ordinance requires that the lease be provided to the city for review as part of the application process. Also, if the property is being rented or leased, there is a requirement that the property owner have been notified of the intended use of the property and that the owner's consent for that use be provided to the city in writing.